So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt the counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kid say, mess around and find out. I guess that's not the quote, but let's close.
Welcome to Trial Breakdown TV. Today, we're taking a closer look at a courtroom case filled with controversy, repeated warnings, and a defendant whose actions continue to raise serious concerns before the court. The case involves Maurice Hankey, a young man appearing before a judge after a series of alleged violations that have put his future freedom at risk. What starts as a bond hearing quickly becomes far more intense. Defense counsel asks the court for another opportunity, arguing that the defendant deserves a chance to get back on track. But prosecutors present a troubling pattern of behavior that includes alleged violations of court-ordered conditions, questions about compliance, and concerns over whether previous chances have been taken seriously. As the hearing unfolds, tensions rise and the judge is faced with a difficult decision. Should the court extend yet another opportunity, or has the line finally been crossed? Stay with us as we break down the key moments from this hearing, examine the arguments from both sides, and uncover the decision that could change everything.
Court calls the case of the people versus Maurice Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, except one.
All right, it's your motion.
There's a probably motion to take the previous PCC hearing. My client's bond vote from privileges from the jail suspended due to allegations that he cut off his tether and contact with the complainant. Following that particular bond hearing, the instructed my client to not contact the complainant with period from the jail. Also instructed my client that if allowed to be back on bond, we would ask the court to.
The defense is asking the court to show mercy, arguing that Maurice Hankey should be given another chance to remain out of custody. According to the attorney, the defendant's record does not include any prior felony convictions, which the defense believes should weigh in his favor. This is a point often raised during bond hearings. Rather than focusing solely on the alleged violations, the defense is encouraging the court to consider the defendant's background and the possibility that he can still follow the rules moving forward. The difficulty, however, is that the court is also reviewing allegations that previous conditions were not followed. When a judge has already extended trust and concerns later arise about compliance, convincing the court to grant another opportunity can become much more challenging. As the hearing continues, the central issue becomes clear. Should the defendant receive another chance to prove himself, or have recent events already undermined that possibility?
Hopefully, Judge reinstate his original bond. Tether, I would know Judge that he has no prior criminal, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the plaintiff subsequently. Now, I just found out today some transcripts. Obviously, people address this, but some of the language that was used in conversations. I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contact plaintiff even after his bond. And so I say this, Judge, again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. He is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something, it means it. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond. And if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. So at the very least, there's a restriction on his phone privileges to contact me.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then
This is the moment when the atmosphere in the courtroom begins to change. The judge's concerns are no longer subtle. Based on the allegations being discussed, the court appears increasingly troubled by what it sees as a repeated failure to follow previously imposed conditions. Consider the situation from the court's perspective. A defendant is granted the privilege of remaining free while a case is pending, yet questions later arise about whether those conditions were respected. When that happens, the judge must carefully evaluate not only the individual incident but also the broader pattern of behavior. Judges often recognize that people can make mistakes. However, when concerns continue to surface, the court must also consider accountability and the importance of ensuring that its orders are taken seriously. At this stage of the hearing, the focus shifts beyond a single alleged violation. The larger question becomes whether the defendant can be trusted to comply with future court requirements if another opportunity is granted.
you know, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on a motion. However,
At this point in the hearing, the prosecution shifts the discussion from allegations to evidence presented before the court. According to the prosecutor, the record includes numerous communications, multiple attempts to make contact, and statements that raise serious concerns about compliance with court-imposed restrictions. These details are presented as part of a broader pattern rather than an isolated incident. From the court's perspective, the issue is no longer limited to a single alleged violation. Instead, the focus turns to whether the defendant has demonstrated a willingness to follow the conditions that were previously ordered. This is often a critical moment in hearings like this. Judges must determine not only what allegedly occurred, but also what those actions suggest about future compliance. When evidence appears to show repeated disregard for court directives, the conversation quickly shifts from granting another opportunity to protecting the integrity of the judicial process. As the hearing continues, the court is left to consider a difficult question. Has the defendant shown that another chance is warranted, or do the circumstances point in a different direction?
in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls, as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request of the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number. If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but it's close, but I did pretty good. I said it okay right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. It's very about myself. I can't say that I'm not in here for nothing. You know, obviously think I am. Yeah. I just want to apologize. You know. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. Again, please show mercy. Please. That's all that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I would ask, if possible, what if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both victims' new numbers and old numbers, so there should not be any more
calls coming through. All right. Thank you.
Thank you very much, Judge.
Thank you, Your Honor.